Start? ठीक है. Good evening everyone. So today in this session of weekly current affairs edition, we are going to study certain important topics which were in news throughout the previous weeks. So this session, as you know, is being intended to create with reference to civil services mains examination. So here we will try to look at the highlights of the major topics and editorials which were in news, giving you a brief background about them, and then we will continue on what is the relevance of such current affair topics in your examination. Okay. Since so much is going on around us in this month particularly, so there's this farmers protest is going on. Before that we had the labour code bill which was passed in the parliament. So in this session we are going to see the major highlights of these major bills, and we'll study what sort of effect are they going to cater on the intended sessions. Okay. So now we first start with the labour laws. So I hope most of you must be aware that for now, since time immemorial, so by this I mean since independence, we were having a very heavy amount of labour laws which were in working, and there was a lot of backlash because of these laws. So if a normal person also thinks about the relevance of labour laws and why do we actually have labour laws in place, so you can start your thinking basically from the Industrial Revolution. So here I am talking about the 18th century Industrial Revolution, where England was the country which had started off with the setting up of industries. So how did this need of labour laws came about into being is, as industries were being set up in European nations and subsequently in the colonies also, there was a growing awareness about the working conditions of the labourers, the wages which they were getting, and the social security benefits they used to have. So from your modern Indian history, you must remember that Indian handicrafts were giving a very tough competition to the British manufactured textile goods. And ultimately that was the time when acts were passed initially to favor the British companies, but subsequently it became a practice to secure the rights of the labour. Okay. So in that direction, since 1947 we have been having acts which were meant for the welfare of labour. To name some of them, you must have studied also the Industrial Disputes Act 1947, then you had the Trade Disputes Act. Okay, so like this we actually had a large number of labour laws in place. Why is this dichotomy especially related to labour laws? Because see, labour is a subject which falls in the concurrent list of our constitution. So we know when I say that a subject is falling under a concurrent list, what do I mean by that? That both the central as well as state legislatures can pass laws on them. So that is where the dichotomy actually begins. So when center is making a certain law pertaining to labour and the state is also making it. So always there is a tug of war and difference of opinion, and as we know in most of the cases when we talk about lists in the concurrent section, the central law always prevails. Okay. So we also had national labour commissions in place which always recommended that we have to urgently bring about a concise amount of labour laws in India. So that was the framework where the concept of labour reforms originally originated. Okay. So in that direction, so recently we have seen that the parliament has passed bills related to labour laws, and if we believe the government, the way they have categorized the existing labour laws into broader sections, so they are trying to cater to make the labour laws in a concise form so that they can be implemented in a proper manner. So how can we actually bring about concise form of these existing labour laws? For example, we can categorize them into broad headings. So some labour laws are exclusively catering to industrial relations, some are about social security, some are about wages, and some others are about occupational health hazards. So as I mentioned all these subcategories, the pre-existing labor laws have now been divided into these 4 clauses. So these 4 are actually the umbrella clauses which we are talking about, and the existing labor laws have been subsumed under them. Okay. So this is how the central government is claiming that they have actually concised 29 labor codes into 4 labor codes. So this is the whole concept of labor codes. And why was it in news? Because along with concisely placing them under broader heads, another thing which the government has done is they have tried to bring about certain reforms in these laws also. What sort of reforms am I talking about over here? See, if some of you have read about the Industrial Disputes Act, you must have read about this provision also, that certain establishments which were having 100 workers, they were not allowed to retrench workers before seeking permission from the government. So this was the law. So at that time, what used to happen? Any firm, to bypass this law, they used to hire 99 workers, okay, and then they used to hire 1 worker on a contract basis, and the cycle used to repeat. Okay. So because of such repercussions, the working condition of the labor was compromised. So in that direction, the government has increased this limit to 300 workers, by which I mean that now any establishment which has about 300 workers should get a written approval from the government before firing their workers. Okay. So such sort of minute reforms have been brought about, but otherwise time will tell that will they actually be helpful in being called reforms, because see, the exploitation of labor can happen at any scale. Okay. So this is what the government has done. So in a brief manner, we are going to have a look about the labor laws, okay, and what sort of provisions have been amended. Okay. As I told you, we will study them under 4 broad heads: industrial wages, industrial relations, wages, social security, and occupational health hazards. So after hearing this short story, it should occur to your mind that in Constitution also we already have certain regulations in place which are actually aiming to regulate the proper working conditions of laborers. Yes, you must have read fundamental rights and the directive principles. So we have certain rights and principles which are actually targeting proper working conditions for laborers, non-employment of children in hazardous industries. So we all have read about these laws which exists in our Constitution. Then what was the need for a proper elaborate labor law legislation in place? See, we need to enumerate properly the working conditions of the laborers, the number of hours of work they put into, and the overtime which they work for. For example, under the new labor codes, the government has come out with the proposition that any worker who works for overtime, he should be paid double of his ordinary wages. And there are other provisions, like a worker cannot be asked to work for more than 9 hours a day. Okay. And there are weekly limits also, capping up to 48 hours a week. So these intricacies had to be taken care of. That is why we had elaborate labor laws in place. But since there was duplicity and multiplicity of laws, so this was urgently needed. Okay, that is why there was a need for concise labor reforms. So that is why we are now moving forward with the 4 codes. So other than work timings, wages, overtiming, another more critical concept is of social security. So you all must be aware about contractual laborers also, right? So we have certain workers who work for a certain period in an organization, and if they are employed on a contract basis, then they are kept devoid of certain incentives which are given to their counterparts who were employed on a permanent basis. So this sort of difference is always there, we know that. And another industry which was permanently excluded from the social security net was the gig economy. So what do I mean by gig industry? The freelance workers, okay, who work project by project basis. So such working population was always outside the social security net. So that is what precisely these labor codes are precisely trying to do. So they are trying to include the gig economy also under a proper social security safety net. Okay. So these sort of reforms have been initiated in India, and time will tell whether they will be applicable on a very large scale or not. Okay. So there are certain provisions which are open to be changed upon depending upon the backlash they receive from. For example, this term of 300 workers retrenching before you have to get the central government's permission. So this has received a large amount of backlash from various trade unions. So the government has kept a window, okay, that okay, we will go about reforming these acts also. That is why you will study a special section in labor codes which is about delegated legislation. So what is it? It means that the government has kept with it certain power related to certain subjects. So time to time, when the need is felt, the government will keep on changing these provisions according to the demand from the labor industry. Okay? So this was in brief what has been done in relation to the labor code bills in India. Now let's see the provisions one by one. So as I already told you, labor falls in the concurrent list of the constitution. That is why there is multiplicity of laws. So both parliament and state legislatures can make laws. So the central government stated that there were about 100 state laws and 40 central laws which were cumulatively governing the labor industry in India. So you can consider how much of mayhem it can create. Okay, labor inspectors, so we had this culture of Inspector Raj in India, so whereby the inspection officers used to collect large amounts of bribes to give a certain clearance. So this happens even today. Okay, why does that happen? Because you have multiplicity of laws, there is duplication and there is no proper enforcement of a single law. Okay. So there were 40 central laws and 100 state laws which were regulating various aspects of labor such as industrial disputes resolution, working conditions, social security and wages. So the second National Commission on Labor, so this National Commission which was set up in 2002, this came out with the recommendation that the labor laws in India require a urgent reform. Okay. So they found the existing legislations to be complex with archaic provisions and inconsistent definitions. So why were the provisions of India's labor laws archaic? Because we were sticking on to the provisions which were made by the Britishers. So since we have acts which are dating back to 1947 and 48, okay, that was the whole problem, that with time we have not amended the labor laws in favor of our economy. Okay, that was the issue. And it was pointed out by the second National Commission on Labor. So to improve ease of compliance and ensure uniformity of labor laws, the National Commission on Labor recommended consolidation of central labor laws. So this is what the labor code is all about. So now what are we talking? We are talking about consolidating the existing labor laws broadly into umbrella subsets. What are those subsets? So we have industrial relations, first one, wages, social security, safety and welfare and working conditions. So see, this year we are talking about the passage of labor codes is 2020. And when was all this proposed? It was proposed back in 2002. So it has taken so much amount of time to actually reform labor laws. So added to the apathy being presented to labor which was being pre-recorded, we also have a report by the periodic labor force survey. So what does this survey say? that 70% of regular or salaried employees in the non-agriculture sector did not have a written contract. So, look at the non-formalization of workforce in this country. So, we are talking about 70% salaried people who are working without any contract being signed. Also, this report pointed out that 54% of them were not eligible for paid leave and 52% did not have any social security benefits. So, this was pointed out by this survey. Now, what is the speciality about India that even after having so many labor laws, why did we fail on such a large scale? So, the single most problem which we have over here is labor enforcement. Law enforcement in India has been very weak. Okay, that was the issue, and it has not protected the workers adequately. So, as a result of all this pressure which was being built upon the government by way of recommendations of the National Labour Commission after the report of this survey, the government in 2019, it introduced these bills. Okay, what did they propose? That we are going to consolidate all these acts into certain codes. So, they consolidated them into 4 codes. So, what are those 4 codes called? The Code on Wages, Industrial Relations, Social Security and Occupational Safety. Okay, these are the broad ones. So, at that time last year, 1 code was passed in the parliament and ultimately 3 of them were sent to the parliamentary standing committees. Okay, so deeply they were studied upon and finally they were passed on in this year, September. Okay. So, the labor codes on wages and industrial relations applies to all establishments. So, these labor codes, though they have been divided into certain subsections, they are not umbrella legislations which are going to be applicable to all establishments. What do I mean by establishments? I mean factories, okay, which are in place. So, case by case basis, it has been proposed by the government that the labor code on wages and international relation will be applicable to all establishment. The code on social security and occupational safety continues to apply to establishments over a certain size. So, what are these factories? These are the factories which employ at least 20 people. Okay. And what do I mean by occupational safety? So, we have this subheading in the labor codes also, occupational safety. Think about the workers who are working in a mine. So, how many of them are exposed to the chemical and fumes which are released from the mine, because of which they are killed anyway. Okay, that is called occupational safety. Think about children working in cracker factories in Sivakasi in Tamil Nadu. Okay, so what sort of a hazardous factory they are working in? That is occupational safety. So, if somebody is working in such a factory which is actually endangering their health, they should have a social security benefit along with that job also. Okay, that is the whole premise of having a occupational safety and social security which has been clubbed together. Okay. However, the occupational safety code states that the applicability thresholds will not apply in those establishments in which hazardous activities are being carried out. So, as I told you, depending upon the case, the conditions applicable for the factories vary. For example, wages code is applicable to all with limited exceptions. Social security and occupational safety, this code applies to establishments which have 20 or more workers. And here, when I talk about a proper occupational safety code, so it is applicable to establishments having 10 or more workers, but it is applicable unanimously to all the hazardous industries. Okay? So, there is no cap on that. Further, it also makes provisions to notify a separate social security fund for unorganized workers. So, this is the highlight of the labor code, that they are actually talking about social security benefit for unorganized working population. That said, the code increases the thresholds for factories from 10 to 20 with power and 20 to 40 without power. So, these are the thresholds on the number of workers which the factories should have to apply this code, alright. The code on social security enables the government to formulate schemes for the benefit of unorganized workers, gig and platform workers. So, this I have already told you that people who are already working in an organized sector, they have access to all sorts of social security benefit and schemes. Some of their salary already goes into the national pension scheme. Okay. Other than that, they also have the provision of voluntary provident fund. But here we are talking about gig workers. So, gig workers are freelancing people and platform workers. So, here the code on social security is widening its ambit to include the gig economy also. Okay. The codes on industrial relations and occupational safety allows the government to exempt any new establishment from their provisions in public interest. So, why this exemption has been provided for any new establishment? So that when a new establishment or a factory is being set, they should not be bogged down by the number of labor codes we have. So, that is why to make that factory thrive, it has been initially exempted from these provisions. Okay. So, this we have to remember that any new establishment will be exempted in public interest. So, see, this was what we were talking about, the Industrial Disputes Act of 1947. I told you that it required factories, mines and plantations employing 100 or more workers to obtain prior permission of the government before firing workers or before closing down its establishment. Now, this threshold has been increased to 300, okay, but the government has already said that they are open to reforms in this clause also. So, see, the Industrial Relations Code increases this threshold to 300 workers, okay. So, from 100 they have increased it to 300. But it is flexible to be amended after opposition from the trade unions. So, I already told you that the government has reserved certain subjects to legislate upon under the section called delegated legislation. So, under that particular section, they can amend whatever rule they want to, okay, which is facing a backlash. So, they are open to amendments, while retaining the notice and compensation requirements specified under the IDA. So, under the IDA, they have only tampered with the number of workers, okay, from 100 they have been increased to 300. So, now any establishment which has at least 300 workers has to get a permission from the government before closing down or before firing of people, okay, that is the clause. But the remaining clauses related to compensation requirements and etc., they are as it is, they have not been tampered with, okay. Now, next context is we are going to talk about is labor administration. So, as I told you, what was the problem which we have in India, that there were multiplicity of labor laws, that was the main issue. So, that is why we actually needed a concise labor codes in place. So, labor laws have distinct complaints requirements for employing units, and multiplicity of labor laws has resulted in multiple inspections, returns and registers. So, I told you about the Inspector Raj. So, whereby any inspector is coming to inspect your factory at any point in time. So, there will be multiple inspections, okay. So, the owner of the factory will have to face multiple issues while trying to catch out a deal with every inspector. So, the regulations will stop him from carrying out his day-to-day work. That also acts as an inhibiting factor in the growth of any establishment, okay. So, that was one issue. It has also been argued that the labor enforcement machinery has been ineffective because of poor enforcement, inadequate penalties and rent-seeking behavior of inspectors. So, what is this rent-seeking behavior which has been quoted here? That the inspectors who are actually meant to give approval to the factory or establishment after checking it out thoroughly. So instead they ask for a particular amount of rent from the owner periodically to give him hassle-free approval. Okay? So that is nothing but bribe. Other than that, we had inadequate penalties. For example, a factory is flouting certain norms, but there is no adequate penalty which is actually stopping the factory from indulging in such practices. So that was an issue. And poor enforcement has always been an issue with labor laws in India. The codes create enabling provisions for web-based inspections. So this is certainly a reform in the positive direction. So now the labor code is talking about web-based inspections rather than normal physical inspections, whereby the inspectors used to visit the establishment multiple times. So that has been ruled out now. Okay. We are talking about web-based inspections which may be accompanied by random inspections in some cases, and there is also this provision of third party certification. So whereby a third party can actually come and have a look at the factory, okay, see whether they are flouting the regulations or not, and then certify them and approve their proposal. Okay. So these are the reforms which has been initiated. So to do away with multiplicity, we have actually compressed everything into 4 codes. So now we have web-based inspections also, random inspections also, we have adequate penalties also. So why see, look at this provision, the codes have increased the quantum of fines and the imprisonment in several cases, and it allows for compounding of offences in certain cases. So what do I mean by compounding of offences? So let's say a factory owner has flouted a certain norm for the first time. So a certain penalty will be imposed on him. Suppose he doesn't pay that penalty. Then what will happen? His penalty will get compounded, and in future he may also be imprisoned. So all these adequate punishment and safeguards are also put in place now. With regard to dispute resolution, the Industrial Relations Code removes the requirement for reference to the government and publication of award in the Gazette and replaces the tribunals with 2-member labor tribunals. So now if any sort of dispute has arisen, the aggrieved person has to directly go to a 2-member tribunal. So out of the 2 members, 1 member will be judicial and the other will be the administrative member. So what is this? Dispute redressal mechanism is also being made stronger. So if we try to point out the reform areas which has been brought out by way of Industrial Relations Code, what will come to your mind? Firstly, that they are also including gig workers in the net. Second, dispute addressal mechanism is there. Third, the quantum of fines have been increased. Okay, so all these are steps in the positive direction. Now, we have another concept of contract labor, where I told you that there are millions of people, firstly, who are working without a contract, and then there are people who are working under a contract but they do not have access to a proper social security net. So we have talked about that earlier. So see, it has been argued that labor compliances and economic considerations have resulted in increased use of contract laborers. So when we say that a certain establishment cannot fire workers arbitrarily before seeking approval from the government unless and until they have a minimum of 300 workers, what do we mean? We mean that that firm can actually hire and fire 299 workers because they have to seek approval from the government only when they reach the 300th worker. Getting it? So that increases the amount of people working under contracts. So obviously the 299 people that factory is going to employ, they are not going to be permanent employees. They will obviously be contractual labor, okay, and they will not have any access to social security benefit whatsoever, okay. The share of contract workers in factories increased from 26% in 2005 to 36% in 2018. And the share of directly hired workers fell from 74 to 64. So these data, they talk for themselves. So the directly hired people population has actually fell down. That naturally means that the contract labor is on rise. Okay. Contract laborers have also been denied basic protections like assured wages. So this is why we have the Minimum Wages Act. So that any person who is working for certain hours for any establishment, he should get a minimum amount of wages. Okay, that was the whole concept of having such regulations. Currently, contract labor provisions apply to establishments hiring at least 20 workers, and this code has increased this threshold to 50. So from 20 they have increased the threshold in contract labor legislation to 50. It prohibits contract labor in core activities. So you must be knowing about core areas in the economy of India. So in core activities, contractual labor is not permitted. Other than that, in non-core activities, it is permitted. So we have a proper list of the non-core activities, which includes sanitation works, security services, any activity of intermittent nature, even if it constitutes a core activity of an establishment. So clear, they are trying to minimize the contractual labor also, so that more and more people come under the ambit of direct employment. And once people start falling in the ambit of direct employment, they will have access to social security benefits, health insurance, etc. Okay, that is the whole concept of these codes. It shifts the primary responsibility of providing welfare facilities from the contractor to the principal employer. Now see, this is a step in the positive direction. So whenever we talk about contractual employees, what comes to our mind? That there is a certain contractor who has hired these employees and he have provided access to the employer. Okay, that I have recruited for you 20-25 people who will work for you as laborers. Okay. So ultimately, if I talk about the welfare of those contractual laborers, who will take care of their welfare requirements? So earlier, the contractor was responsible to look after all the needs of those laborers. But now, these labor codes have shifted the responsibility from the contractor to the principal employer. So from now on, the principal employer has to maintain certain standards of occupational safety. Okay, he has to take care of those employees. Okay, this is also a major shift. It also provides for automatic absorption of contract workers into the establishment of principal employer where they are engaged through a uni-licensed contractor. So if certain workers are coming to the principal employer by way of a uni-licensed contractor, then in future subsequently they will become a part of the organization itself, okay, like permanent employees. The Industrial Relation Code introduces provision to employ fixed term labor. So what were they trying to do? They are trying to minimize the contractual labor to whatever extent they can. They are trying to regularize people, okay, in terms of employment. In context of trade unions, so trade unions have always had a very unanimous sort of image when it comes to them. For example, whenever there is a certain law which is being passed by the parliament, we'll have at least 20 trade unions which are protesting against that law. But can the government keep on listening to each and every trade union and then keep on changing it because one or the other will protest? No. So since we have so many numbers of trade unions in India, so this code actually talks about only considering the grievance of that trade union which has a population percentage of 51% which is engaged in that occupation. Getting it? So they are trying to directly hit that segment which is actually getting affected by the legislation. Okay? So this is the history of trade unions, that okay, what sort of a precarious image trade unions in India have. So there are a large number of registered trade unions, including several within an establishment. There is no criteria to determine which union can formally negotiate with the management because n number of trade unions, they actually claim that they want to have a negotiation with the management of any establishment. Settlements are made with unions and they are only binding on the participating unions. So sometimes when the establishment or government for that matter happens to listen to the demands of one particular trade union, then those laws will apply only to the members of that union. So this doesn't mean that all the workers in a cumulative fashion will be benefited because of that. Clear? So questions have been raised on the extent to which non-employees can also be permitted in trade unions. So see, this is actually the scenario that when you see a trade union protesting, it is not necessary that all the people who are protesting in that march are actually an employee of that particular organization against whom they are protesting. Okay, that is why this criteria has been brought about, that the Industrial Relation Code makes provisions for recognition of a negotiation of unions with 50% membership. So you must have a certain amount of validated membership, only then you will be considered to be eligible to have a negotiation with the management. Clear? This has been done to prevent the multiplicity of trade unions which we have today in India. Okay? So that only those trade unions have a weight who have 51% membership. So other than that, there are no changes which have been made with respect to outsiders who can join in the trade unions. So that ratio has been fixed to 33%. Clear? So these are the major points on which legislations have been brought about. We have highlighted the major ones and what sort of repercussions they can have. This I have been periodically talking about, delegated legislation. So in normal English also, delegation of authority means that a certain authority has been given the power, has been delegated the power to amend the rules from time to time. So with that particular scenario in mind, the government has actually kept with it the aspects of rule making. So if in future or in near future also any change has to be done in these labor codes pertaining to the threshold for layoffs. So I talked about the Industrial Dispute Act, whereby 300 is the number which has been fixed for an establishment to have as number of employees, after which they have to seek permission from the government before laying them off or closing the establishment. So in that case, if there is a backlash, the government has the responsibility, they have this power to tweak that number also. Okay? So clauses related to retrenchment, closure of the establishment, all these powers have been retained by the government. Okay? They have had this delegated authority of legislation and they can keep on amending it. So they can set thresholds for applicability of different social security schemes. They can specify safety standards and working conditions. Okay, they can design the norms for minimum wages. So these are the subjects on which the government can legislate, the government can amend from time to time. Okay, this they have kept in power. So now we have a list of the labor codes and the pre-existing legislations which they are subsuming within themselves. So when I talk about the code on wages which has come about, so it is subsuming Payment of Wages Act 1936, Minimum Wages Act 48, Bonus Act 65 and Equal Remuneration Act 1976. And Occupational Safety Code subsumes these many acts. So this is how 100 plus labor legislations have been concisely brought about under the umbrella setting of 4 labor codes. Okay, similarly, Industrial Relation Code is subsuming the Trade Union Act, Industrial Dispute Act and the Industrial Employment Standing Act. Okay. Code on Social Security is subsuming all these. So we know we had these provisions of Maternity Benefit, Payment of Gratuity Act, we had the Employee State Insurance Act, we have EPFO provisions 1952. So all of them are relating to social security in one or the other way. So that is why compositely they have together been kept under the social security framework. Clear? So this is the division. This is for you to look upon that, okay, how come the government has actually brought about 140 subjects under the ambit of 4 codes. Okay? You can just have a look at this list. Okay. After the labor codes, the next major issue which we are seeing in the news since about a month now is the farmers' protest on the borders with Delhi. So what is the whole issue? What are the acts which have been passed by the government? What is the issue about MSP? So the farmers are precarious that the government is trying to abolish the whole MSP regime, whereas the government is saying otherwise. So we are going to study those 3 legislations in brief. Okay, we'll study the provisions of these legislations, and then you can make out by yourself that who is right. Okay, are the farmers who are fighting for their rights, are they right, or the government as it is claiming to actually move forward in the direction of reforms, are they right? Okay, so I hope most of you must be clear with the main issue which is with the farmers and the government. The issues range from dismantling of APMCs. So what are APMCs? These are the agricultural produce markets or mandis where actually the farmers bring their produce to. Okay, so they have been in place and currently they are under the state governments. The second issue is about MSP. So the government is claiming that they are not trying to shatter the MSP, but the farmers are precarious that the MSP regime will be gone. That is why they are asking for the amendment of the law over here. The third issue pertains to contractual farming. So the government has come out with the law whereby a farmer can actually sign a contract with the potential buyer of his produce before the sowing season. Okay, and this contract will be valid for 1 year at a time. The government is saying that by way of contract farming, we are trying to benefit the farmer by actually giving him a safe hand where he can actually sell his crop after the cropping season. The farmers on the other hand believe that contractual farming Raj, which was present during the Britishers' time, is trying to erode the ownership of their land. Okay, so these 3 are the bones of contentions between the government and the farmers. So we'll study those legislations, what the government has proposed and what do the farmers want and why is this unrest. So apart from that, I hope you all know about the WTO agreement which India had signed, whereby we are being continuously pressured to keep the subsidies below a particular level which is called as the de minimis level. Yes, so India has always bargained for concessions in every WTO ministerial conferences when it comes to providing subsidy to its farmers. And what sort of subsidies does the Indian government provide to the farmers? It is primarily by way of fertilizers and by way of electricity. Okay, so that much is the bare minimum which is required for the Indian farmers to survive. So if we talk about abolishing the subsidy on electricity and abolishing the subsidy on fertilizers, will the Indian farmer be able to sustain himself? So even today the farmers are not getting prices for their produces. So we saw a Sikh farmer who was telling on the television that the corn which he has grown, it was being sold off for rupees 2 per kg and the same corn flour was being sold in a mall for 150 rupees per kg. So why is such a price difference between the farmers and the consumers? Where does the whole money game go then? Okay, why are the farmers fighting to thrive? Why do we have so many suicides in India, especially farmer suicides? So all of these are cumulative issues which we have to talk about. Okay, that is why when you face a question on this issue in your mains answer, you will have to necessarily you will have to support your answer with convincing arguments. Okay, only then the weight of your answer will be considered. So now we'll study what are those legislations. what has the government proposed and what is the problem the farmers have with the legislations. Okay, the conclusion you have to draw. What according to you is correct? What do you feel about these legislations? Will the Punjab and Haryana APMCs become like the Bihar APMCs? Okay, so we know that APMCs were abolished in Bihar back in 2005. Ultimately what happened? The farmers, they became so poor that they had to actually migrate to other states and do labor. Okay, so you have seen many people from Bihar also who are protesting because they do not want Punjab to become another Bihar. So there are so many issues related to this particular topic and it has been in news for a while. So let's see what the government has proposed. Okay. So the first law which the government calls is the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020. So look at the name of this law. So farmers produce whatever the farmer is producing, trade and commerce. By trade and commerce I mean the farmer has to sell his produce in a certain mandi. Now that particular aspect is trade and commerce. Promotion and facilitation. So the government is trying to portray that they are actually promoting and facilitating the sale of the farmers' crops. Okay. So this is the name of the act which was passed in 2020, and what do the farmers and normal people call it? APMC bypass law. So why have we given this name called APMC bypass law to this act? Because this particular act is telling us that the farmers can trade their crops in any state of this country. There is no interstate tax. And if a Punjab farmer wants to sell his crop in Kerala, he can do so without any hurdles. This is what this law is proposing. So permits trade outside the APMC mandis. It also permits intra and interstate trade. So here the government is destroying the monopoly of the APMCs. So until now what was happening? There are certain APMC mandis which have been set up, okay, in every district. And all the farmers bring their produces over there and they sell it off. The government is now telling the farmers that we are giving you one more option. Why stick on only to the APMCs? Go wherever you want to go, sell in any market you want to. That is what they have portrayed. Added to that, they are also telling that there is no tax whatsoever on interstate and intrastate trade. Okay, so a farmer from Punjab can go to Kerala. That is their proposition. What the farmers are saying, who will cover the travel cost of taking his crop from Punjab to Kerala? Is it so easy as it has been said? Easier said than done. So in quintals and quintals farmers are going to produce rice. Is it possible to take those trolleys from Punjab to Kerala as this act is proposing? So as I told you, now we are getting access to mandis outside APMC mandis. That means there is a clear provision of private mandis. Okay? So private mandis can be set up across the country. Anyone can buy the produce from the farmers, and these mandis are exempted from paying any taxes or fees. Getting it? So this is the problem the farmers have. That why is the government trying to dissolve the APMC when they are happy trading in APMC? But the government is saying that we are giving you more options. Earlier you had one APMC, now you can go to any private mandi and you can sell to any buyer at any cost. So by government's definition, the cost for the farmer in this whole process, the farmer will end up making a profit. But according to the farmer, this is false. Clear? The government argues that this is designed to provide farmers with more choices on who to sell the produce to. So the bill also produces an electronic trading and transaction platform for ensuring a seamless trade electronically. So previously also we have studied about e-NAM portal, okay, National Agricultural Market, which was online. So this is another facet of similar kind, whereby the government is enabling electronic trading also for the farmers. In addition to mandis, freedom to do trading at farm gate, cold storage, warehouse, processing units, etc. So they are actually saying that the farmers are not necessarily bound to sell their produce only in mandis. They can go to a cold house storage, okay, warehouse, and they can go and sell their potato. Okay, so they are saying that we are diversifying the options for the farmers. They argue that instead of providing them more choice and hence better price, it will leave them at a mercy of the few private players who will organize as cartels, thus setting the price. So are we aware of the concept of cartels? What are cartels? Cartels are certain specific groups of people or organizations who become powerful with time and they start dictating prices. So the most famous cartel which we have is oil cartel. Okay, the Middle Eastern countries which have large amount of oil, so they dictate the prices of the oil. Cartelization of oil, that is what is called. So the farmers fear that instead of having more choices, the private mandis will obviously be in a hand of few private players who will tend to monopolize the trade. So they will fall at the mercy of those private players. That is the issue, that is the backlash the farmers are giving. That instead of earning more, they will actually end up being dependents. The private players will dictate prices. They will create cartels of their own. That is what the problem of the farmers is. Okay, they have said that this provision of the government is not facilitating our trade, but it will end up inhibiting our trade. Okay. Farmers argue that APMC mandi will continue to attract taxes and hence it will disincentivize traders. So as I told you, according to this act, the private mandis are exempted from any sort of tax. But APMCs, as of now, they fall under the state government. They are intended to pay a certain tax or a certain fees to the government. So the farmers say that since APMC has to pay a certain tax to the government, whereas the private mandi on the other hand has not to pay any tax to the government, hence traders will get disincentivized to come and trade in APMCs. This is a disincentive for the APMC, and ultimately the popularity of APMC will fall down to such a level that the trading at APMC will virtually stop. Okay, this is the grievance of the farmers. The fear is that farmers with little bargaining power will have to sell outside the mandi in an unregulated trade area where the relatively more powerful buyers are able to dictate price. So the farmers are saying that we will become price takers and not price makers, because the private players will form a cartel of their organization and they will dictate prices to us. Okay, this is the issue with this first act, which is called as APMC bypass law. Clear? The provisions are clear? Okay. Now let us study how do APMCs actually work. Okay, what is the work process of the APMCs? So they are regulated by state laws, this we already know. They were set up with the objective of ensuring fair trade, yes. What are the powers of APMCs? What all can they do? So they can regulate the trade of produce by providing licenses. Okay, they give licenses to farmers, to commission agents, to adhatyas. Okay, that is what is happening. So they give licenses to people to trade in the mandi. They levy market fees or any other charge on such trade, and they provide the necessary infrastructure within their markets to facilitate the trade. For example, when a farmer is coming off with his trucks to the mandi, first unloading of the crop has to be done. So after unloading has been done, it has to be filled down into guinea bags, okay, and it has to be stored off. All that process also needs infrastructure. So where is that infrastructure coming from? APMC mandis, the commission agents, the adhatyas, they are providing that infrastructure to the farmers. Now the farmers say that if APMCs are dissolved, then where will we have access to such infrastructure from? In private mandis. It is not possible. Okay, that is the problem. So the Standing Committee on Agriculture observed that APMC laws are not implemented in their true sense and they need to be reformed. So this we have already seen. We have studied in economics again and again that the APMC markets are not functioning properly, they have certain backlogs, etc. But all that needs reforming APMCs, not abolishing them altogether. Okay, that is the premise the farmers are giving, that they have a certain way of trading of their crops, they have certain licenses with certain adhatiyas who are providing them infrastructure, who are providing them the facility to come and trade. If APMC is dissolved, who will be responsible for providing all that infrastructure to them? Okay. So the bottom line argument is farmers will become price takers and not price makers if that act continues to be in place. Okay. That was about APMC Bylaw Act. Now coming to contract farming law. What is the name of this act? The Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act 2020. Look at the name of this act. What is it trying to tell you? Empowerment and protection of the farmer. How? By price assurance. So as I told you, the farmers by way of this act, they can sign a contract with a certain player or a certain buyer who agrees to buy his produce at a certain price before the sowing season. Okay, this is the whole concept. The government is saying that this way the farmer will have a assured buyer of his produce. Ultimately, the government is supporting this clause. Okay, so what is the clause? It provides for a national legislative framework to enable contract farming where an agreement can be made between the farmer and the buyer before the sowing, under which the farmer is contracted to sell his produce to the buyer at a predetermined price. Okay? And at present now, if I forget this law for a moment, at present, how does the trading happen? Before the sowing season, the government announces the minimum support price for certain crops. So it has been mandated that the government has to announce MSP for 23 crops. But naturally, generally, it is being done only for rice and wheat, okay? Especially if I talk about Punjab and Haryana, who are the main cultivators of these two crops, okay? So when the MSP is declared by the government just before the onset of the sowing season, then the farmer sows his crops, and after the harvesting, after all the process has been done, he goes to the APMCs and he gets access to the minimum support price if he is fortunate, and he sells his crop down at the mandi. Here what the government is saying, you will have a one particular buyer. He will agree to buy your crop at a predetermined price before the sowing season. Okay, that is called as contract farming. Now since the farmer has signed the contract with the buyer, he will not have the option of going off to the APMC mandi and selling his produce at the MSP. Even if the MSP comes out to be larger than the amount he has promised to the contractor. Clear? This is the catch over here. The minimum period of the agreement will be one crop season, okay, or one production cycle. The maximum period is 5 years. So this is actually the time frame for which that contract can be signed, 1 year to 5 years. The farming agreement must provide for a conciliation board as well as a conciliation process for the settlement of disputes. So they are also adhering to this possibility that in case a dispute arises, we will have a conciliation board where the farmer and the contractor can come up with their dispute. So this is what the government has argued. At first, all the disputes must be brought before the board for resolution, and if the dispute remains unresolved, the parties may approach the SDM. So this is also a major clause of resentment in the farmers, that the act is saying that if there is a dispute between the farmer and the buyer, first they will go before the tribunal, and after that they have the access of going off with their disputes only to the SDM. okay, not an authority above that, not to the courts. So that is also a problem, because the farmers believe that the appelling authority in this country are the courts. So why has the government actually came up with this clause where they can approach only the SDM for this particular matter? That is the catch, okay. Contract farming in India involves many malpractices against farmers, including one-sided agreements, delayed payments, quality-based rejections. So let us assume that a farmer has signed a contract with the buyer, and after the harvesting season, if he tries to sell his crop to that buyer, the buyer may refuse on certain accounts. Depending upon, he may say that the quality of the grain is not what he had assumed. That is a clause, okay. So such sort of uncertainties are still there. And then what the farmer will do? And if the contractor takes the farmer's grains also and he doesn't pay him for a year or two, so where will the farmer go? Again, in case of dispute redressal mechanism, they can only approach the SDM at the maximum level, at the highest level, not to the courts. So what sort of regulation facility will this clause provide? Okay, so that is the grievance which the farmers have. Alright. They also fear that contract farming will enable large corporations to take over their lands, as the law lacks adequate redressal mechanism for farmers. You must have seen in these farmers' protests that the farmers are protesting against Reliance Jio also. So they are protesting against Adani Group. So they are protesting against all the established industrialists which are active in this country. Now, why is that happening? Because they believe that these large players will actually be the ones who will set up private mandis, who will become contractors, and they will try to buy the grains from the farmers. So in this way, the farmers doubt that their entire lands will be confiscated by such large players, okay. That is why there are slogans against Reliance Jio and Adani Group also, because this can happen, that in near future these large organizations, private organizations, they will try to usurp the land for their own ends, for industries, okay. That is also a clause of fight between the government and the farmers. So this is the second act, okay, which is totally about contract farming. The third controversial act is Food Hoarding Law, or also called as Essential Commodities Amendment Act 2020. So we already know that Essential Commodities Act was in place earlier also, that the government can actually come up with a legislation of against hoarding certain type of objects which are necessary for the usage of the common population. Okay, now they have amended that clause. So it provides that the central government may regulate the supply of certain food items like cereals, pulses, potatoes, onions, edible oil seeds and oils under extraordinary circumstances. So what are those extraordinary circumstances? Famine and war. So under such circumstances, the government can actually regulate the supply of these. Okay, what do we mean by regulating the supply? What will the government do? So they will procure all these food items from the farmers and they will start hoarding them. So what will happen? The farmers will have to sell off their produce at the existing prices, while the government will keep on stockpiling them in their cold storages, and the government will supply that particular food items only when there is an inflation, because ultimately when there is demand for a certain commodity and the supply is not there, what will happen to the price of that commodity? It will skyrocket. Okay, that is why it is called as food hoarding law. But the government is saying that it will interfere in such cases only when the circumstances are extraordinary. And they have also defined that what according to them is an extraordinary circumstance. What is it? War, famine, extraordinary price rise and natural calamity of grave nature. So if any of these conditions persist, the government has the power to hoard the food items. Okay? It requires that imposition of any stock limit on agricultural produce must be based on price rise. Okay, they also have a stock limit. So what is the problem the farmers have with this law? It is that the government at its whims and fancies at any time period can declare extraordinary circumstances and they may end up hoarding the food items, and ultimately the farmers will not get the price which they actually deserved for that product. Okay, that is the issue. Now, since it is too much in news, we have actually come up with a proper section where we are going to talk exclusively about the MSP, okay, the minimum support price. There is a lot of hue and cry around this topic. Now see, as I told you, MSP is generally announced for 23 crops, okay, before the sowing season. But at the time of procurement, so generally the grain which is most procured at the MSP rates is wheat and paddy, okay, rice. And that too, the farmers, it's not that 100% of the farmers of this country are actually getting access to the MSP rates. No. Their grains are also rejected, saying that the quality is not fine, that there is a certain level of moisture content in that grain. So at this time also we do not have 100% assurance that at a particular quoted MSP the government is going to buy the grains. Okay, it may buy the grains or it may not buy the grains, it may be rejected also. Okay, so we were highlighting this point, that normally MSP is announced for 23 crops, but in reality sustained procurement is only being done for wheat and paddy in Punjab and Haryana. So farmers fear that with these laws the government is signaling that it will go out of the MSP regime. Okay. So this also we have actually talked about. I told you, no, the WTO negotiations where there is insistent pressure on India to actually lower the food subsidy bill. So researchers also believe that this step has been taken in that direction to reduce the number of subsidies which the government is giving to its farmers. Okay. So this is the whole issue between the farmers and the government. Now we have studied all the 3 acts, what the government is proposing and the counter opinion of that law given by the farmers also. Now after studying them, you decide that what is right. Are the farmers right? Okay, should they fight for their rights? Can the existing mechanism of MSP and APMCs be strengthened to actually benefit a larger amount of farmers' population? Is there actually a necessity to come out with private mandis? Because we have a classic case study where the failure of APMCs or the abolition of APMCs had actually resulted in marginalization of farmers in this country. So as I already quoted you about the Bihar case study, in 2006, Bihar repealed the APMC Act. Okay. Now what happened? This resulted in lack of marketing infrastructure. See, I already told you APMCs are actually providing the farmers with the necessary infrastructure to unload their grains, get them packed in the gunny bags and then sell them off. But when I am talking about private mandis, will such infrastructure be available to them? So the abolition of APMCs in Bihar, it proved to be of a very grave threat to the farmers of Bihar, and majority of them were marginal farmers who have a land holding of less than 2 hectares. So ultimately they gave up farming and they moved to other states in search of labor employment. Okay. So this is a classic study which we already have. So if the farmers are actually presenting their point of view that if MSP and APMCs are abolished altogether, their fate will also become like that of the Bihar farmers. Okay. So this is also a valid point because we already have a live example of what happens when you abolish the APMCs. Okay. So this was all about the farmers' protest and the laws of the government. So this is a probable question which we can have this year. So make sure you have balanced opinions, and whatever take you take up in your answer, make sure you have necessary arguments to support your answer. It should be weighted. Okay. So the next topic which we have is governing the OTT services. So what do I mean by OTT? Over the top platform services. So when we had lockdown in place since March 2020, whole year has passed since then. So we saw n number of movies, TV series and whatnot which were played on OTT platforms like Amazon Prime, Netflix, Hotstar, YouTube, etc. So the government, see, right now we have laws and regulations which are pertaining to regulate the print media, okay, to regulate newspapers, TV channels, etc. But there was no law in place to regulate the OTT services. And this came to the limelight during this lockdown scenario, when majority of the films were not able to actually telecast themselves in the premier theatres. They ended up releasing on the OTT platforms. So after that, recently the government has came up with the proposal. They have also amended certain acts and they have added sections to regulate the OTT. Why? Because right now the content on OTT is unregulated. So what do I mean by regulated content and unregulated content? So when we are talking about unregulated content, what do we mean? There is no certification which they have to obtain. Okay, there is no fencing on the language, the quality of language which you can use, and they can ultimately influence their audience also. So before 10 days we had this news that a person killed 2 people after being influenced by Mirzapur 2. Now what is this? Influencing. Okay, so if there are no proper regulations and without any regulations the content is being streamed on the OTT platforms, the government has decided to regulate them. Okay, that is the issue. That is the current affair topic which we have now, OTT services. So OTT means over the top media services, which is any online content provider that offers streaming. Okay, now the type of OTT services can be of many types. So WhatsApp which you use, that is also OTT. Over WhatsApp you are allowed to do voice calls, video calls, all this is OTT. Okay, that is voice. And on the other hand, when we talk about Amazon Prime and Netflix and other platforms, Hotstar, what do we mean by that? There we have a proper quality video content. Okay, so these services are called as OTT. So they circumvent the traditional media distribution channels like the telecoms and the cable providers. So we know that the telecom agencies and the cable TVs, they are regulated by certain regulations, but that was not so with the OTT services. So that is why the government has actually came with the caution that we need to regulate these services also. Okay. So there are 3 types of OTTs: messaging and voice services, application ecosystems, video or audio content. By messaging and voice services, we already know about Facebook, WhatsApp, yes. Application ecosystem linked to social networks like LinkedIn. So nowadays, whenever you log in into any social media networking site, they ask you about this option: log in with your Gmail, log in with your Facebook, or you want to create a new ID. Getting it? So they are interlinked to each other. So see, these are application ecosystems. Third quality, video audio content, which we are precisely talking about. The streaming of movies, short films, series on the internet. So which is available for all. Okay. So government has brought OTT platforms like Netflix and Amazon Prime under the ambit of Ministry of Information and Broadcasting. That means what? There will be certain laws and regulations in place before any content is released on the OTT platform also. Okay, so specific sections have been amended to make sure that they are regulated. While the print is regulated by Press Council of India and television is regulated by Cable Network Act, content online was unregulated. So this has actually come into focus only because of the lockdown, right? because so much content has been absorbed in this lockdown by the people that the government has actually sought a need to regulate this platform. Okay. So, see, when I am talking about regulating the content which is available on the internet, do we mean that we do not have any kind of provisions in the constitution which enable such sort of regulation? See, as we already know, under Article 19, we have freedom of speech, but with restrictions, yes. So, under IPC, we can punish anybody who has indulged in the distribution of work of literature which is obscene. So, if you remember, consequently before 2 years there were many novelists who were banned also because of the material, the content on which they wrote. Okay. So, the government has powers of declaring a certain content to be obscene and then applying the charges of IPC on you. Okay. And we know IPC is a punishable offence, it is the penal code. Okay. So, what sort of conditions have been enumerated by the government on behalf of which the content can be deemed to be obscene? So, if it has the intention to outrage the religious sentiments, okay, any act of publishing defamatory content or anyone who insults women's modesty. So, we have such clauses already in place which are trying to regulate content. Okay. So, that is why indirectly we also feel that the OTT content also needs to be regulated, because already we have regulations in place for other modes of networks also, for cable TVs, for radio, for print media, for newspapers, for everything there is a regulation. Okay. For example, the Indecent Representation of Women Act acts towards making sure that there is complete prohibition of indecent representation of women in advertisements, in books and movies. We have the POSCO Act for children and the IT Act which also carries imprisonment term, okay, in case of cyber crime, cyber security, all these things. So, when everything around us is regulated, why not OTT? We should regulate that also. So, that is the premise of government. And when the government was actually in the process of regulating the OTT platforms, the OTT platforms themselves came out with the self-regulatory framework. Okay, they said that, okay, we as a platform are enumerating certain codes which we will follow. It is like a self-regulation code. So, they came out with this regulation code. They said that we will not have malicious content on the program, and they have a list of these codes, but the government rejected that self-regulatory code out front, and the government decided to regulate the OTT by themselves. Okay? So, the government did not support this code. And why is this concern specifically very important when it comes to India? Because India is currently the world's fastest growing OTT market. Okay, then look at the population India has. Now, how many people must have consumed content on OTT platforms during the lockdown? Okay, so all that content is going to influence the people also. So, that is why India is the potential market, and it will become the 6th largest market by 2024. Okay, that is why there is a need to regulate it. Now, what are the issues with the content? Why did the government actually decide to regulate OTT? Was there any complaint or was there any malicious content on these channels? So, many of them were under public criticism for their vulgar content which harms public morality. So, again, if you try to go back to IPC sections, they actually converge with this particular clause. In the name of artistic freedom, OTT platforms are streaming inappropriate content. So, many people say that the OTTs have become notorious to hurt religious sentiments. Okay, now mostly cinema halls have taken a backseat. Now all the movies are being released on OTT. So, that is why they are in the limelight. And added to that, we have allegations like this also. Okay, that is why the government is going to regulate the OTT platforms. Okay. So, this is about future of OTT in India. Content is the key to success, rural demand will grow, high growth forecast, health and fitness. For every sector we are going to have content which is going to mainstream. So that is why it becomes necessary to regulate it at a certain time period, because with time India will grow endlessly as a market for this particular content. Okay. So next important topic is about the Polar Silk Road. So you must all be aware about the standoff which India and China has been having this year precariously. Before 2 years, China was in news because of the OBOR initiative which they took, One Belt, One Road, if you remember. So they have two types of ancient routes which they are trying to actually revive. One is the Belt and Road Initiative, called as the BRI initiative or OBOR, which is actually traversing the land front. Okay. It is actually trying to replicate the Silk route which was existing in the ancient times. Similarly, Chinese also came out with the Maritime Silk Route, which was doing the same purpose of trade, but along the ports. So they were hopping from ports to ports of various countries. Now Chinese have come out with the Polar Silk routes. See, here we can see. So this red colored route is the Polar Silk route. So if you look at the passage which they have envisaged over here, they are traversing the Arctic Circle, the Arctic area. And with growing global warming, the polar ice in the Arctic has also melted. So it is enabling the movement of ships also, but it is not that easy, because Russia has actually icebreakers, okay. Russia has about 42 icebreakers which enable the movement of ships, but China has only 2. So since Russia is already having a larger part of Siberia within itself, a larger range of the Arctic Circle, it has more potent abilities to actually regulate trade in that area. But China has come out with the Polar Silk Route. So this is the Silk Route they have produced, starting from Rotterdam and then ending over here in Dalian. Okay. Before that, I told you about the road initiative, BRI or OBOR, which we call, that is along the road. Okay, this one is OBOR. And the Maritime Silk Route is this, from ports to ports they are hopping, dark blue color. Getting it? So this map makes it clear that the Chinese intentions are to go global. So they are exploiting the whatever available route to maximize their trade. Okay, that is their agenda. So China State Council Information has released a white paper on Arctic policy for the first time. So they are venturing into the Arctic route for the first time, and the Polar Silk Route is a historic step for China. So the foundation of this road was to be the development of enhanced maritime trade through ice-free Arctic Ocean, and as well as infrastructure and other offshoots projects. See, basically again if you look at the map, normally if China tries to trade from this port over here to this port, it is going to take a lot of costs to cover. Okay, port hopping has to be done, the distance traversed is larger, but look at this route. If they discover a ice-free route, it is going to be more easier to have trade across the Polar Silk Road. Okay, so they are actually seeing it not as an alternative, but as a compounding factor to the Maritime Silk Road which is already existing. Getting it? So, but as usual, they have came out with the white paper which is saying that they are emphasizing on peaceful utilization of the Arctic. Okay, so they are going to use it only for peaceful purposes. And already if you are aware of the Arctic Council, China is also one of the 13 observer nations, and I already told you that because of climate change, the Arctic ice is actually melting slowly. So it enables the movement of ships, okay, a bit easier, let's say by 2 to 4%. Okay, so that is being exploited by China. But if I view it from the point of view of geopolitics, it is going to be a very concurrent initiative which has to be looked on with a precarious eye, okay, because they are actually virtually trying to come out with a new trade route bypassing Russia also, okay, because Russia is already the biggest player in that region, okay. So this will change the geopolitical equations. So there is already a shipping through PSR, but not much. Around 1 million tons was shipped in total last year, because see, even if we say that the ice is melting because of global warming, it will not melt to that extent that you can have a very hassle-free trade route as you have on the normal waters. Okay, it is not going to be that easy. Why is China eyeing the Arctic? Because the Arctic area is resource rich. It has nickel, copper, coal, gold, uranium, tungsten and diamonds. It produces 10% of the world's oil and 25% of the natural gas. So obviously it becomes a potential area of resource rich region, that is why China is eyeing on it. The Yamal Peninsula in Arctic Circle contains the world's largest proven gas reserves which are untapped. So we already know that oil is the next gold, right? So now Middle Eastern countries, they have this whole cartelization of oil politics because they have the most amount of oil in this world. But when we are saying that there is the potential of natural gas reserves in Arctic Circle, then obviously China is trying to seize that opportunity before any other country does. So they have also proposed to construct a fiber optic link connecting China, Japan, Russia, Finland and Norway. So one more advantage of using the polar silk route is that it can reduce the distance from Europe to China by 40% compared to the Suez Canal route or the Malacca Strait route. Okay, that is also a reason. See, when I am telling you that they are trying to ship their contents from Europe through this route over here in China. Okay, so it will become economical, because otherwise the ship has to traverse the Strait of Malacca, then it has to pass the Suez Canal. So this dashed route, this route is very large, okay, in terms of distance compared to this route. This red line route is easier to traverse, okay. That is why China is eyeing the Arctic. But always there are certain concerns about this particular initiative also. As I told you, Arctic is not an ice-free region. So even if global warming is happening, it has considerable amount of ice, and the ships necessarily have to have access to icebreakers if they have to traverse smoothly in that area. Okay? So the shorter distance will not necessarily make it more economical, because simultaneously you will have to invest in more robust ships. Okay, you will have to hire more icebreakers also. So ultimately the cost of that round trip is going to increase, okay, this way or that way. Satellite coverage is poor, okay, so navigation will also be difficult, okay. So ice class ships should be used, and Russia claims the right to regulate shipping through the polar silk road. So now there will be a potential clash between Russia and China also. Okay, the question now is whether Beijing will be able to navigate both the economic diplomacy required to build this ice road. Because if they have to build this particular route, they have to be on good terms with Russia also. Okay, because they are trying to traverse the area around Russia. Alright, so that was about polar silk route. Now we are going to talk about India quitting the RCEP. So I hope all of you know about RCEP. We had a very simple question in UPSC mains in 2016, whereby we were asked about the members of RCEP, potential members of RCEP. So these are nothing but all the 10 ASEAN members plus 6 countries which have free trading agreements with ASEAN countries. So the membership was ASEAN plus 6, but now India has decided to leave it. What is the reason why India is not joining it? So before this, if you remember, before Donald Trump was elected, there was this Trans-Pacific Partnership Deal which was called as TPP. Okay, now it is called as CTPP, but at that time to counter TPP, RCEP was created. Okay. So after Donald Trump was elected, he decided that USA will not be a part of the Trans-Pacific Partnership Deal, and all the countries along the Atlantic Ocean, they were a part of that TPP deal. Okay. So now after that, what happened? RCEP was proposed to counteract the TPP, and the countries which were becoming the members of RCEP, they had the potential for 30% of global GDP. So this is a very great amount when 30% of the global GDP is being regulated by some countries who decide to be a part of a certain negotiation or a certain agreement. So India was all in terms with the RCEP, and it was a member of RCEP also initially, but recently it has left it. So see, RCEP is a proposed free trade agreement between 10 ASEAN nations and their FTA partners. By FTA partners, I mean free trade agreement partners like India, China, Japan, Korea, Australia and New Zealand. It accounts for approximately 30% of the global GDP. Okay, it was established or proposed to be established in 2012. Now, what is the purpose of this deal? So, they want to create an integrated market which is spanning all the 16 countries. So, that was what RCEP was proposing to do. So, if you look at their objective, which they have stated, is to achieve a modern, comprehensive, high quality and mutually beneficial economic partnership agreement among the ASEAN member states and ASEAN's FTA partners. Okay, but India had a issue with the RCEP trade negotiations. One was about the reckless dumping of China's imports inside India. One was about, the second issue was about the most favored nation status which India was supposed to give to other member nations. And the third issue was about the concept of rules of origin clause, okay, which was not agreed to by the rest of the nations. So ultimately India decided not to join it. So see, India decided not to join RCEP, stating that inadequate safeguards and lowering of custom duties will adversely impact its manufacturing, agriculture and dairy sectors. So that is why we have decided to quit it. So as I told you, there was an issue about Chinese imports. So we know the dumping policy of China. So what is the dumping policy? They will create certain commodities and then they will dump those products into India. Dumping means deliberately selling those commodities at a price lower than the price of that good in the destination country. Then what will happen? More and more number of people will try to purchase that Chinese product. So now there was no resolution of this issue, and already India and China were on a standoff. So India was not willing to trade off on this reason. Second concept relates to rule of origin. So see, in trade economics, whenever a certain country signs a certain agreement with another country in terms of imports and exports, there is a clause called rule of origin, whereby, for example, if India has signed an agreement with Australia to purchase oranges, okay. Now, those oranges which will come from Australia will come up with a tag called made in Australia, okay. Now, that tag cannot be arbitrarily be pasted by anybody, by any factory, no. So, there is a proper clause, proper documentary framework which ensures that those oranges are actually produced in Australia and not in any other country and then sent to Australia, and then from Australia they are sent to India. Okay, that is the thing. So that rules of origin clause was also not acceptable for India. That was also an issue of contentment. So see, growing and widening trade deficit with the ASEAN nations was a cause of concern. So the trade deficit of India with all the ASEAN countries, most of the ASEAN countries, was also increasing. First point of friction. Second, lack of protection against surges in imports. So there is a concern about dumping of goods such as dairy and farm products, electronic items, especially from China. So RCEP agreement is trying to promote integrated trade. So they are actually trying to make imports cheaper. So already China is dumping goods in India, and if the products become even more cheaper, it is actually going to flood the Indian market. So India had a problem with this clause. So RCEP agreement will make imports cheaper because the deal required India to abolish tariffs on more than 70% of goods from China, Australia, New Zealand, and 90% from Japan, South Korea and ASEAN. So ultimately what will happen? India will not have the right to impose a certain amount of import duty when the goods are being imported from any of these countries. So ultimately it will lead to more and more deepening of trade deficit which India has with these nations. So already India is having deficit with these nations, and if these clauses would have been put into place, the deficit would have become even more deeper. Okay, so that was also a cause of concern for India. Third concern was on a possible circumvention of rules of origin, which is the criteria used to determine the national source of a product. So these concerns were also not addressed. So because of these three issues, India decided not to be a part of the Regional Comprehensive Economic Partnership Agreement. Okay. So both Australia and New Zealand are waiting for free access to India for their dairy products. So this may affect the domestic dairy farmers also, and India wanted RCEP to exclude MFN obligations. So you all must be knowing about MFN obligations already. So when we give a tag of most favored nation to a certain country, then we cannot increase the price of goods from that country over a certain level. Okay, they have to be treated at par with the prices of that particular good in our country. Clear? So again, that will also lead to trade deficit for India. And added to all the factors which we already know, the tensions between India and China related to the Galwan Valley clash was also a reason why India decided not to join the RCEP. Now, what is the way forward? Can India join it? What will be the advantage? Okay, so we have an option for review also. So the RCEP has come up with a review clause, and if India wants to become a partner in RCEP, it can become again, first thing. Second thing, India has been aggressively promoting its Act East policy also. Okay, so where India came out with Look East policy first, and then they promoted the policy to Act East. So all the countries which we are opting out to trade from, who are the member of RCEP nations, are all eastern countries to India. Okay, so if India has to vigorously work on its Act East policy, we should probably be a member of RCEP. On the other hand, what alternatives do we have? If we want to join RCEP again, we have a window of 18 months, we can join it again. Okay, but if we do not want to join it, then we are always at our free will to sign separate free trade agreements with each of the participating nations, and with most of the countries India already has FTAs. Okay, so that is always an option, signing bilateral negotiations or being a part of free trade agreements on a country basis, talking one-to-one. Okay, so that was about RCEP and the issues India faced by being a member of RCEP. Now talking about tourism post-COVID. So since March, everybody was confined to their homes and there were no trips which were planned, and even if people had planned trips already, they were not able to execute them. Now what is the status of tourism after the corona era? How can we revive tourism? So that is the question over here, because there are certain very small island countries whose 80% of the revenue is because of tourism. Okay, and since corona happened, their revenues have been impacted on a very large scale. And recently, the chairman of Niti Aayog, Amitabh Kant, he said that India has a very great potential and it will bounce back on the tourism front after the corona era, because we have great culture, okay, we have the potentiality of attracting tourists from all over the country. So that is a matter of immediate redressal, that we need to think about revival of tourism in the post-COVID world. So how the country can actually move forward in providing safety to the visitors. Okay, we have to have proper hygienic facilities, sanitation, cleanliness. So all these are prerequisites. Other than that, a new concept of tourism has emerged because of corona also. So how many of you have heard about vaccine tourism? So if there is a potential question in your mains examination on this topic, don't forget to talk about vaccine tourism. So see, recently UK, US, they have given approval to this Pfizer drug, okay, which was being built by BioNTech company. So now those countries have access to vaccines. So what are the travel agents in other countries doing? They are actually providing people vaccine tourism packages. So by vaccine tourism, what do I mean? That if I am from India and I want to get vaccinated against coronavirus, so I will go to a trip on England and I get vaccinated. So tourism is also done and vaccination is also done. Okay, so that is a new concept which has emerged. It is called as vaccine tourism. Apart from that, India is also progressing on the yoga and Ayurveda front, which the Ayush minister has called out to be medical tourism, that in spite of corona, India will continue to attract tourists because it is famous in its philosophy of Ayurveda and yoga. Okay, so these are the potential impacts. So let us look at a certain amount of facts and figures, that how many people were actually engaged in tourism as an occupation and how many of them have lost their livelihoods also. So COVID is the biggest challenge which has threatened the global tourism, and the UN has estimated a reduction of 78% tourist traffic across the world. This means that the international tourist arrivals could drop by 1 billion. Now this is a very big number for those countries who are sustaining entirely on tourism, okay, the small island countries especially. Tourism is one of the world's major economic sectors, and in 2019 it accounted for 7% of the global trade. Okay, so that is why it is necessary to address it. It provided 1 in 10 jobs also, and especially for some island states, 80% of the revenue was because of tourism. Okay, so now what sort of issues are the world countries facing because of COVID? So see, because of COVID, there was regular visits to biodiversity parks, wildlife sanctuaries, national parks, etc. Okay, so now the revenue stream from that particular source has dropped to a significant extent. So what is the effect? The sudden fall in tourism cuts off the funding for biodiversity conservation. So the funding to conserve biodiversity has been cut off. About 7% of the world's tourism relates to wildlife. So ultimately it will lead to poaching, looting, consumption of bush meat also. So all those efforts which were being made to prevent poaching, to prevent hunting of exotic species of animals, so all have gone down the drain because tourism has subsided and these incidents have actually increased. So many countries have also ended up closing their World Heritage sites also because there are no visitors. And ultimately we know that the upkeep of World Heritage sites also requires continuous funding process, okay, so that they can be kept in a manageable position, right? So these are the issues which we have with tourism in post-COVID world. This is what we were talking about, vaccine tourism, whereby people can have access to vaccine tourism packages who want to travel to England to take the shots. But the most important and trivial issue which is highlighting current scenario is that United Kingdom is now having a new mutant strain of coronavirus. So now what has happened? All that proposed vaccination tourism packages will not be able to materialize right now, okay? Because since the disease has again relapsed in that country, it will not be safe to travel to such destinations. So such tourism is going to remain tipsy-turvy, but certain efforts in a particular direction may make it sustainable, alright? So we need to redefine, refocus, change the game, save businesses and save jobs. What can the central government do in this scenario? It can give funding to upkeep the tourism sites, okay, to maintain World Heritage sites, to regulate poaching of tigers, okay, to preserve the exotic species. What if you are not getting a revenue from tourism, but the government can, by way of aid, actually prevent tourism, okay? That is the bottom line. So as I told you that Amitabh Kant has already said that yoga and Ayurveda will continue to attract tourists in this country. So don't forget to mention medical tourism, which is about yoga and Ayurveda treatment in India, okay? So we always have a potential of medical tourism when it comes to India. Now talking about another very important topic, it is called as virtual courts. So see, the Supreme Court during Corona on March 25th, it came out with a guideline that though social distancing norms are in place, okay, and there is this threat of this viral attack, we should make sure that justice is not delayed or denied to any person. So there were the provisions of having virtual courts. So what do we mean by virtual courts? By that we mean that the hearings are being done online, that there is no necessity for the judge, the lawyer and the litigant to actually be physically present in the court, okay, rather they can be present by way of video conferencing. That is what do we mean by virtual courts. Now since at this point in time virtual courts aroused because of the need, okay, because there were specific provisions for social distancing, etc. So virtual courts became need of the hour. But can we universalize this particular phenomena? Since the Supreme Court of India and the High Courts, they have a backlog of lakhs and lakhs of cases. So is it not efficient for the Indian courts to actually move on the online route? What is the problem? Okay, so there are certain cases also whereby the witnesses are not willing to come to the court, so they suspect that they will be killed, etc. So the case of virtual courts will come handy in these cases also. So here in this topic we are trying to analyze the fatality of the virtual courts in India, that to what extent will they be fatal or to what extent can they be alive in India, okay? Is it necessary to always have physical courts? So primarily we firstly need to know the difference between virtual courts and a computerized court. A computerized court need not be a virtual court, okay? A computerized court is a court where it has basic access to computer, okay, where the documents are stored in a computer, but the hearings are still happening physically. But when I am talking about virtual court, I am telling you that the judge, the lawyer, the litigant, everybody is on a conference video call sitting in their own spaces and houses, and that is how the hearing is being processed, okay. So the Supreme Court exercised its plenary power to direct all high courts to frame a mechanism for the use of technology during the pandemic, because though there was a pandemic for about 9 months, the work of judiciary cannot be stopped. So that is what Justice Bobde said, technology is here to stay, okay. That means we need to use technology in a judicious matter even in the cases of judiciary. The Supreme Court passed directions for all courts across the country to use video conferencing for judicial proceedings, okay. An e-court is a court in which matters of law are adjudicated upon in the presence of qualified judges and which has a well developed technical infrastructure. So as I already told you, there is a difference between an e-court and a computerized court, and it will enable courts to make justice delivery system affordable and cost effective. So ultimately, if everything is happening online, so justice delivery will also become faster, obviously. There are hearings in which people do not appear, right? What does the court do? It keeps on postponing the date of the hearing. So to avoid all such circumstances, why not move on to virtual court project? So back in time, 2005, there was this e-court project policy which was proposed also. Now what was it called? National Policy and Action Plan for Implementation of ICT in the Indian Judiciary. If we had implemented it back then, today we would have not have such a large amount of backlog of cases. Okay? So today we have crores of backlogs. It aims to provide efficient and time-bound citizen-centric service delivery as detailed in a e-court project charter. Okay? So we need to develop, install and implement decision support systems in courts. Now what is the problem? Why India is not able to adopt this technology of virtual courts in a easy manner? Why don't we actually hug this practice of virtual courts? Why are we redundantly dependent on physical courts? Because see, India lacks the infrastructure. First and foremost, what is the amount of internet outreach in this country? Can we expect a litigant sitting in a rural area, he is trying to have a hearing, virtual hearing, will he be necessarily be able to connect to the judges and the lawyer? First thing. So India firstly needs to work on technical manpower also, infrastructure also, only then we can materialize this dream of virtual courts being true. Okay, though we have been having this initiative since 2005 in India, but it has still not been materialized. So during the pandemic, we had certain hearings which were in virtual courts. So according to constitution, is there a possibility, can we have a virtual court? So we all have studied this in polity. Article 130 states that the Chief Justice of the Supreme Court may, with the consent of President, cause benches of the Supreme Court to be set up in different places. And though we know that till today we have only one bench of Supreme Court which is in Delhi. Okay? So constitutional power is there with the Supreme Court Chief Justice. If he wants to make the entire court system online, he can do so. Okay? That is what the constitution says. And apart from that also, we should not expect each and every litigant. For example, the petitioner is from Andaman and Nicobar. So should we expect him to come all the way to Delhi for a certain hearing? So that is not feasible also, right? So if we have virtual courts in place, this process will become even more faster. So what are the advantages of e-courts? We know we'll have a transparent mechanism. Witnesses will not fear their life. Okay, they'll be there. Okay, they'll have time saving tactics. It will protect the interest of witness. So everything will get regulated in a transparent way as we have always wanted it. Provided we have the technological infrastructure and the learned manpower which is required to execute this project. Okay. Another very interesting fact is that the litigation process will become faster. So why does it take years and years to solve a certain case, to solve a certain court case? So if we have the concept of virtual courts, this will also become easier and faster. Okay. Increased accessibility to documents anytime and anywhere. Since we are talking about virtual courts, so everybody will have all the required documents in a proper filed and saved manner. Okay. So they will be available at their disposal at any time the judge calls for. It is tech savvy also. You once save the document, you email it to your lawyer, it's there to stay. No need to carry out all the physical documents from one place to another, right? It will help in computerization of workflow management also. Clear? Now, what are the disadvantages of virtual courts and what is the way forward in case of India? So, the biggest threat which is looming on India right now is cyber security threat. because we do not have a robust cyber infrastructure which can actually fight against any sort of data theft which can happen. Okay, and these data are very crucial. The judgments which the judge has to deliver, we cannot expect everything to be available on an insecure platform. Okay, so since the sufficient infrastructure is not there which is going to protect the interest of the litigators and the lawyers, implementation of this particular plan on a foolproof basis is not possible. Non-availability of electricity in most of the villages, and along with electricity, internet will also vanish. Okay, so the outreach of electricity and internet is a major cause of concern. Lack of technical manpower, and how many people do we have in courts who can actually help or aid this process of streaming of virtual courts. So for that we will have to train certain manpower who will enable this process to become more and more faster. E-courts will also prove to be cost intensive. Why cost intensive? Because you will have to set up the entire infrastructure. You will have to set up computers, internet connection, optical fiber networks, electricity. So ultimately it will amount to a large amount of costs also. Now what is the way forward? How can we draw a road map which actually will lead to this way, to the way of virtual courts in India? So it is critical to draw a pre-decided framework and lay a concrete roadmap to materialize this e-court scheme in India. So obviously what will be the counterpoints? We need to have a robust security system. We need to build infrastructure, so in terms of internet, okay, in terms of cyber security. If all this is taken care of, then it will become a very user friendly process. Okay. And see, now when we talk about litigations, they go on for like 25 years. So the Ram Janam Bhoomi case, it started off in 92, and when was the judgment delivered? This year. So look at the quantum of time which has been elapsed in delivering of judgments. So that is how the backlog of cases they are keeping on accumulating, right? So for India, if we want to ensure service delivery in a very transparent manner and in a very proper manner, we need to shift to virtual courts only. But see, as we know, the process cannot be done overnight. Since already we have heard about breaches of data leak in Aadhaar card also. Okay, last year in United Kingdom, the health data was theft of. So all these conditions have to be looked upon. We need to first primarily start off with building a proper cyber security system in place. Okay, so that is when you can ensure that you can have a live proceeding, a proper litigation like a court on a video call. Okay, that is the way forward. Alright, so we wrap up this edition of Weekly Current Affair Roundup with these topics. So we have discussed 7 topics today. So in the coming session, we will again discuss topics which are relevant to the mains examination. So I hope you will try to make out of these notes. It will benefit you. All the very best for your examination.